Welcome once again to Lehto's Law. Here's Steve Lehto.
Several people sent me a story out of Ohio from WKBN, Channel 27. Ohio judge suspended for ordering court spectator to take drug test. Now, you might know that if you are, driving a car erratically and come into contact with law enforcement, they might ask you to do a sobriety test. And if you're on probation, for instance, they might be able to make you take drug tests while you're on probation. But if you are simply in court watching proceedings, generally speaking, these things would not apply to you. But Chelsea Simeon wrote the story out of Fostoria, Ohio. A court spectator's refusal to take a drug test led to the suspension of an Ohio judge. The Ohio Supreme Court announced that a judge named Mark Repp from Tiffin Fostoria Municipal Court will be suspended for a year without pay as a result of saying a woman was in contempt of court for refusing to take a drug test while she was simply watching court. This is a unanimous opinion. There's not much to argue about here. The Ohio Supreme Court ruled that the judge violated four rules governing the professional conduct of Ohio judges and lawyers, including failure to perform all of his judicial duties fairly and impartially. And you might not know this. Some people don't. There are rules that govern how attorneys behave in court. Since judges are attorneys, at least most of them are. I know there's still some states where they aren't necessarily, but the rules that apply to lawyers also apply to judges if they're lawyers. And there are also usually rules of ethics that apply to just judges. So judges usually have two sets of rules: the rules that apply to lawyers and the rules that apply to judges. So the judge was elected to the Tiffin Municipal Court in 2002, and in 2013, Tiffin and Fostoria combined into a single municipal court. This judge has been the sole judge of that court since its inception. The court also operates a drug court program called Participating in Victory of Transition, or PIVOT. In March of 2020, a man was arrested for violating terms of his probation for failing to appear at PIVOT. He was to appear in Judge Repp's court via video from the Seneca County Jail where he's being held. The man's girlfriend went to the courtroom to watch the arraignment and the hearing, so she is simply in the courtroom observing. While other cases were proceeding, the judge addressed the woman on several occasions, suggesting she might be on drugs. Court video showed the woman sitting quietly in the back of the courtroom, bringing no attention to herself. So this is one of the situations where the judge said on the record, I think something's going on. But there are cameras in the courtroom recording what's going on, so we don't have to take the judge's word for it. We don't have to read the record. We can watch the video. And that's what the court did. The Supreme Court watched the video and said, we don't see anything going on back there. She's sitting back there quietly. According to the Supreme Court, the woman did not have a case before the judge, was not on probation, and had never been charged with or convicted of a drug-related case. However, the judge had read the police report regarding the man's case and noticed that his girlfriend was in the car with him when he was arrested. Guilt by association. They do not teach that in law school. Judge Repp paused hearing other cases and announced to the court that he thought the woman was under the influence of something. He stated, I want her drug tested. The bailiff directed the woman to the probation department, and she requested a lawyer when she was told that she was about to be tested. The officer told her she was not eligible for a court-appointed lawyer because she had not been charged with a crime. So then wait. Why are you testing her? How do you have jurisdiction over her? Is it just because she was sitting in the courtroom observing? Can the judges do this? When she refused to take the test, she was sent back to the judge's courtroom. When she returned to the courtroom, she told the judge she refused to take the test because she did not think she had done anything to be in trouble. The judge stated, well, you come into my courtroom, I think you're high, you're in trouble. So the judge said on the record, think about this, there's three parts to that statement. You come into my courtroom, if I think you're high, you're in trouble. So simply by entering his courtroom, he thinks that he has control over you. Now, the court and the judge do have the discretion to control the courtroom, So if someone started jumping up and down the back and screaming during a jury trial, a judge could say, take that person out. They can. They have that power. They have the power to, like I said, simply control and oversee, administrate, or administer the courtroom itself. They have that power. But just because you walk into the courtroom doesn't mean that the judge can then just say, okay, by the way, I'm now going to run you through the probation department. I'm going to now do this. I'm going to throw you in jail. Judge can't do those things, okay? And so, like I said, 3 parts there. You're in my courtroom. I think you're high. So now, this judge has the ability to look at somebody who's sitting quietly and go, I think they've got contraband in their system. I think they're on something illicit. This is a person, presumably, he's never seen before. He read that she was in a car with someone who got arrested, but that shouldn't give him enough knowledge of that person to be able to look at them and guess if they're on something. So if you come into my courtroom and I think you're high, you're in trouble. By the way, you're in trouble for what? What are they testing her for? So the woman responded, okay, I'm not though. I'm not. She denied it. When she again refused the drug testing, the judge found her in contempt and told her that she was sentenced to 10 days in jail, and they could talk about this again if she took a drug test. So presumably she's going to jail for 10 days. At the end of the 10 days, they'll bring her back and say, now do you want to be tested? Well, presumably she won't have anything in her system then. The court's opinion, that is the Supreme Court of Ohio, stated that the woman experienced several indignities while in custody. She was required to take a pregnancy test. Apparently, we test for that now, too. And then a female officer conducted a full body search that allegedly detected anomalies that the officer believed could have been contraband hidden inside her body. A male officer then viewed nude scans of the woman. She was handcuffed and transferred to a hospital for a second pregnancy test and another body scan. The hospital scan found nothing, and she was returned to jail. And by the way, I'm willing to bet that if I didn't bring this up, at least one person in my comments is going to say, Steve, isn't there something in the Constitution about searches and seizures? And when they take you to a hospital and scan your body's interior for things that don't belong there, is that some kind of a search? Hold on, I'm thinking. I don't often stop to think on camera, but... And I'm only laughing because of the absurdity. The judge thought this was okay. Hospital scan found nothing. She was returned to jail. The court ruled that the judge's actions were an abuse of judicial power. We agree with the board's assessment and concluded a 1-year suspension with no stay will best protect the public and send a strong message to the judiciary that this type of judicial misconduct will not be tolerated, the court stated. And referring to the board's assessment, there's often a panel or a board that oversees ethics for attorneys and for judges. And so presumably this matter was referred to the board. The board came to the finding and said, we recommend a year suspension. And the thing is that most of those recommendations by the board in many states are then reviewed by the Supreme Court of that state. So Judge Rep was also required to pay the cost of these proceedings. One of the rare examples in America where the participant must pay for the proceedings, regardless of who brought the proceedings. So he lost, he pays. And it's a year where he's going to not be allowed to be a judge. Presumably at the end of the year, he can be a judge again. I don't know when the next election is for that bench. I hope somebody competent runs for it and gets it. And the guy's been on the bench for approximately 19 years, I think. So maybe it's time he hung up the old robe and put the gavel away and maybe just went off and did some fishing for a little while, because it sounds like the judge doesn't have the temperament to be a judge. And, being a judge is a tough job. It actually is. And there's a lot of jobs out there that are difficult. And you look at the job of a judge and you go, that's a great job. It pays really well. There's some judges that pay even better, and some judges who have lifetime appointments, for instance. But it's a state court judgeship, probably has decent pay, probably gets to set his own hours, probably has a good pension. And the own hours is one of those things. Some judges are very liberal when it comes to how much time they spend or don't spend on the bench. I know judges who routinely hit the bench at 10:30 in the morning after telling people to be in court at 9 a.m. And they routinely take long lunches, and they routinely take off for the day at 3 o'clock unless they're in trial. And so it's a good job to have. And the problem is that very rarely do you get corrected as a judge. Now, you say, Steve, but on appeal. Well, yeah, cases go up on appeal all the time. It gets spun around. And I've seen judges who don't care. I've seen judges make bad rulings on the record, look at somebody kind of like, are you going to challenge that? And I've seen an attorney go, Your Honor, this will get reversed on appeal. And I've seen a judge say, I don't care. Let's see. And case goes up on appeal, gets spun around, gets sent right back down again. I've had it happen in one of my cases where I didn't say it quite like that to a judge. But I stated what the standard was on the record, and I said, Your Honor, as you know, the standard for this is such and such, and what you've just described does not meet that standard. And I've had a judge say, well, you know what to do. You know what to do, counselor. I said, yes, I do. And I was back in front of the exact same judge later. And no words were exchanged, but we were looking at each other. And I know darn well that he knew I was thinking, I told you so. And he was saying, I don't care. No skin off my nose. Because the judge doesn't win or lose anything when his cases go up on appeal and get reversed, spun around, as we say. So here, this judge does something idiotic. Grabs a person, figuratively speaking, out of the spectators in the courtroom and says, I want you drug tested. And when she refuses, contempt of court, 10 days in jail, and off to the hospital for scanning of your body to see if you've got anything hidden in there. Turns out she didn't. Just got a whole bunch of expensive scans done at the taxpayer's expense. So a 1-year suspension, in my mind, is actually short. But hopefully it's long enough to where they can get another judge in there. The community can get to know that judge and then elect that judge at the next election. And that's what I hope happens. So it's a crazy case. Ed, Austin, and Jason all said it. Thanks a lot. Out of Ohio, WKBN, Channel 27. Chelsea Simeon, Ohio judge, suspended for ordering court Spectator to take a drug test. And when she refused, contempt of court and 10 days in jail. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. I had a hard time figuring out why I don't consider cottage cheese to be truly cheese. Problem solved. It just occurred to me.